We're scheduled today for a hearing on a motion to impose jail sentence based upon failure to pay and for interest judgment filed by Mr. Vendesco on behalf of Ms. Stevenson. Mr. Vendesco, are you prepared to proceed on this motion?
I am, Your Honor.
All right, and Mr. Cranmer?
I'm ready, Your Honor.
All right, go ahead, Mr. Vendesco.
Thank you, Your Honor. Judge, can I confirm that the court received the exhibits of petitioner, which number 1 through 9?
I do have those, yes.
Okay. Your Honor, this is a hearing on our motion to impose jail sentence and upon failure to pay and for interest judgment. It was filed back on July 14th of 2025. So basically about 45 days ago. This relates to a hearing, an in-person hearing that we had in this matter back in September of 2022. There had been a motion for contempt filed on behalf of the petitioner against the respondent due to significant outstanding judgments that the respondent hadn't paid. We had a hearing in September of 2022. Well, the allegation was that there were judgments in the amount of, I believe, I've got that amount here, $45,570 for unsatisfied remaining portion of an equalization judgment owed all the way back 90 days from October of 2018, had remained unpaid. And also there was outstanding spousal support that was due back in 2019 of $27,294. At the hearing, Your Honor, the court found the respondent to be in contempt. The court found that there have been no payments on those amounts stated and no efforts to pay. Basically, the court awarded a judgment for that outstanding spousal support total that was the amount of $27,294. Your Honor, I think the court was very generous in awarding only $1,000 of attorney's fees at the time. The court did award that against the respondent. The other, from my perspective, Your Honor, the court was also very generous in allowing Mr. Zemer to purge his contempt by paying and continuing to pay $1,000 a month towards the judgment commencing October 15th of 2022 until the judgment was paid. Your Honor, basically what's happened since then is there have been only a total of, and I've got the tabulation here, I went through every payment on the Kansas Payment Center record. Since October of 2023, there have been a total of 4 months where the payments have been on time. And when I say on time, I mean that the Kansas Payment Center record, which is included as my Exhibit 4, the Kansas Payment Center record shows that it's been received by them, not necessarily dispersed, but received by them on or before the 15th day of the month, consistent with the court order. There are a total of 4 months in that time frame going back to October of 2023, where there's a payment reflected as received on or before the 15th day of the month.
Is it
for many months?
2022 or 2023?
I misspoke. It commenced October of 2022.
Okay.
Thank you for that correction, because I'm trying to be accurate here with my statement, Sean. So thank you. 4 months and basically 29 months where the payment was late, ranging from a couple of days to not at all. There were, in the last 2 years, 2 months where no payment was made at all within the 30-day period. Actually, 3 months. 2 months as of this spring. And then basically, other than being very late to pay, as of April of this year, he decided to stop paying altogether. And so at the point in time that we filed this motion in July, there had been no payment for May, there had been no payment for June, there had been no payment for July. no communication otherwise. Judge, I note that what's happened, and I credit the court, I credit Mr. Zimmer's counsel. Frankly, I credit my client. What we've done, Your Honor, and the judge has basically given us its courtesy to do this. We have had regular hearing setting that they continue to be continued, really just to keep tabs on Mr. Zimmer to encourage him to pay, because otherwise he seems disinclined to follow the court's order, which is really just accomplishes his own purge. Looking back, and this may be redundant to go through these, Your Honor, but we had a court setting in December of 2022, March of 2023, July of 2023, October of 2023, March of 2024, April of 2024, June of 2024, December of 2024, and then in June of 2025. And Judge, there's a reason why we haven't, even though there were 2 months that were missed and most months were late, the issue for my client has been she has to pay for my services. She pays for those in advance when she asks me to file something. And so we've discussed, we're trying to keep pressure as needed on Mr. Zimmer to make these payments, because Your Honor, these amounts were due years ago. And the court's aware of the time value of money. If she would have had these monies when they were due, with the last payments due back in 2019, she could have invested them. They would have had significant value by now. We're still chasing down significant amounts from a 2018 decree. At any rate, if the court wants to know why we haven't been more litigious, it is because there's a cost that my client has to advance if we ask for it, if we actually conduct a hearing, and she does not have the means to do that, and she's just been judicious or careful with her funds. At this point in time, after he failed to pay 3 months in a row, and it ended up being 4 months in a row because there was not a payment made on August 15th, basically there was no option for us other than to file a motion basically for the court to determine that the purge criteria have not been met, for the court to impose a jail sentence on Mr. Zimmer, or whatever action is necessary to compel his cooperation with the court's prior order. And I deal with many different judges, and it's very common for judges to take personal offense when a party refuses or fails to comply with the court order. And again, I credit my client for giving him plenty of opportunities to comply and not being aggressive about this. But the time has come for the court we would request to take some corrective action here. We're also asking for attorney's fees associated with this motion, and that we're asking for attorney's fees in the amount of $1,500 for this new motion based upon the appearance time, preparation of the order, filing it, going back and counting through all of the records and monitoring the payments, or to account for all the payments. Judge, the other thing that we're asking for, the statute, Kansas statute provides in 16204 that any judgment rendered by a court of this state shall bear interest on or after the day in which the judgment is rendered. It's not common for us to request that in domestic actions when their payments have been regularly made, or if there's somewhat of a contemporaneous effort to make the payments. No, we have none of that here. These are 7-year-old judgments at this point in time, almost 7-year-old. And again, if my client would have had the funds, they could have appreciated, she could have had use of those. Instead, we're just spending time and money chasing the funds down. There is an arrearage calculation, an interest calculation included as my Exhibit 2, that basically from the date of each judgment with credits for payments made tabulates the interest. This is from T-Value software that we have for the judgment work that we do in my office. The interest amount that would be owed as for the judgments, the outstanding balances on the judgments of Mr. Zimmer against Mr. Zimmer as of June 30th, which was the last month end prior to this motion being filed on July 14th, was in the amount of $26,065.25 on the remaining principal balance of $43,864. And it may seem like a significant interest balance on the remaining principal, but the basis is because the statute says the interest accrues starting from the date of the judgment award. And these balances
The court dives into past hearings and unpaid spousal support, setting the stakes high.
have been outstanding for so long that it's not an insignificant amount. So it may seem extraordinary for the court to request that the court actually enter a judgment and memorialize that amount. But Your Honor, I don't think there's any breaks or passes to be given to the respondent at this time. Under the law, my client is entitled to interest, and there's no reason why she shouldn't be entitled to collect that at this point in time. So we're asking that the court award that as well. Your Honor, I would note Mr. Cranmer advised me in a message yesterday that there had been a payment of $4,000, which technically would be the last 4 months owed. Unfortunately, and I communicated the same to him, at this juncture, that doesn't resolve today's hearing as far as I'm concerned, because this is kind of, and maybe this is overused, the definition of insanity, which is doing the same thing over and over and expecting a different result. That's what we have here. We can keep monitoring payments. We have to keep having court hearings. We have to calendar those. I end up writing off time to not pass along to my client because we decide she doesn't want to pay the cost of a hearing. She shouldn't have to do that. Your Honor, at this point in time, we want Mr. Ziemer to have to pay the remaining balance within a specific period of time. He's been coddled along too long in this. This is a 2018 judgment, and we'd like him to be required to do that within a specific amount of time to purge the contempt. Otherwise, we want the court to assess a punishment, an actual penalty, because we're almost 3 years removed from this contempt hearing, and there still continue to be issues. Judge, the other thing I would make reference to, I included in when we had the hearing last time in September, it was kind of a sob story. Mr. Ziemer was dying of cancer, or he had been in a car accident, or ABC and other things. Well, I haven't heard that yet because that information hasn't been shared with me. I anticipate there's going to be another sob story. As far as what public information is available regarding Mr. Ziemer, Your Honor, he appears to be doing very well. If you look at Exhibit 5, it's his LinkedIn profile. He is associated with 3 different companies per his profile that he manages: ZA Technologies, Zytec, and Upstate Custom Products. In his background or history, it says that he's the founder and CEO of Upstate Custom Products. I researched that company. It's a South Carolina company. The information on that is in tab 6. The other company, ZA Technologies, it has a website. That is what I was able to print from that is on Exhibit 7 on page 27. Mr. Ziemer is listed as the co-founder and COO of ZA Technologies. Apparently, ZA is the first initial of the last name of the board of directors. Each of the members of the board of directors: David Anderson, Chris Ziemer, and James Holder. Those are all included in the printout. If you review what Mr. Ziemer states about himself, it sounds like he's doing very well. That's what he presents. The tab 8 is the Secretary of State information on both of those companies, that they are valid and viable South Carolina companies. Your Honor, the last one is tab 9. These are social media posts regarding Mr. Ziemer that apparently were posted by his fiance at one time, and apparently now it's his wife, showing their travels. Basically, it appears that this is public information. traveling, basically appearing to kind of live it up. I noticed on page 53, it tracks his, I would say, courtship of her, because she's his fiance, and then they're engaged, and then they got married in May of this year. But if you look at page 53, you can draw your own conclusions. I think they show what they show. On page 53 is a close-up of the rock, the engagement ring that he purchased for her. So, Judge, whatever it takes to have the lifestyle shown with beach pictures, etc., on these social media, that isn't the lifestyle of somebody who's dying of cancer, who is basically living paycheck to paycheck, who is not able to meet the court's minimum requirements for this purge, which, again, Your Honor, we're asking the court to require, to change those requirements at this point in time. And let's stop kind of fooling around. We need to get this judgment satisfied, and just everybody can move forward with their lives. Thank you.
All right, Mr. Vendeska, are you seeking the admission of these exhibits?
Yes, Your Honor, I'm seeking to admit exhibits 1 through 9.
All right, Mr. Cranmer, any objection to the admission of exhibits 1 through 9?
I object to the admission of exhibits 9. They're not really relevant to anything. The rest of it, I don't have any objection to.
Your objection is that they're not relevant?
Yeah, they're not relevant to these proceedings. They have nothing to do with, they don't show any financial information. They show events, they show people. They show a relationship that my client is in. They're not relevant to these proceedings.
Well, I tend to disagree. I think they're relevant. Now, the weight that the court places on them may be varied, but I think they're relevant. So I'll admit 1 through 9. Before I allow Mr. Cranmer to respond, I just want to make sure I understand what's all being requested, Mr. Vendeska. You've indicated you're requesting the court impose a jail sanction for Mr. Zemer. Were you requesting a specific amount of time?
I suppose 30 days, Your Honor. I recognize in the balance here, it really needs to be some amount of time. The balance here is he needs to be paying this judgment. So it may seem counterintuitive. The greatest thing my client is interested in is having him comply with the court orders, and also the court crafting a path to getting her judgment satisfied without us continuing to be in this process for another 5 years.
All right, and then you're seeking $1,500 in attorney's fees. You're seeking interest on the judgment in the amount of $26,000, $126,165.25. And you're asking the court to set a date certain to get the entirety of the judgment paid off?
Yes, Your Honor. Thank you.
Thank you, Mr. Vendeska. Mr. Cranmer, I'll allow you to respond at this time.
Thank you, Your Honor. Well, as the court heard, after a hearing, the court ordered that my client pay $1,000 a month beginning October 15th. The problem I'm starting to have with this is most of this is money judgments. And accordingly, Ms. Stevenson is no more than a judgment creditor like anybody else in any collection lawsuit where you're suing to get a judgment. She got her judgment. You don't get, the judgment did not contain payable at a certain rate. The judgment did not contain provision that has to be paid by a date certain or by a minimum amount of month, so on and so forth. So like any judgment creditor, she has remedies under the law which she can utilize to pursue collection, execution, garnishment, whatever. But it doesn't include modifying the judgment. In fact, to impose now a requirement that so much per month be paid, or that be paid by a certain date, quite frankly, modifies improperly the terms of the judgment that was entered back in at the time of the divorce was granted. You can't go back and retroactively modify that and put terms in that he's got to pay a certain amount by a certain time. That's not what the judgment is. The judgment is X number of dollars. He's paid some of that, but at some point you don't put in provisions for payment of money judgments. You don't go to court and get orders that somebody's got to pay so much per month. That's not how you collect judgments. And I think that's an improper request. And I think it's improper to retroactively modify an order or to now add terms to an order that were not put in place at the time the order was granted. If she wanted it paid at a certain rate, at a certain amount, by a certain date, she could have asked for the court for that back in the day. She didn't do that. That's an improper modification of an order that's been in place for many, many years. With regard to where we are, the court did find him in contempt, and part of this judgment was for spousal support. I want to say about 25,000. I don't remember the exact amount. So when you're enforcing support, that's a little different. So to impose that he's got to make a minimum payment on a support arrearage, that's appropriate under the family law rules, and that's what the court's done. He's pretty much complied with that. In fact, with the payment that he made earlier on Monday of $4,000, he's now paid effective 35 payments of $1,000 or $35,000. That should now eliminate the support portion of this judgment. And this case should be now, these proceedings should now be dismissed, and Ms. Stevenson can enforce her judgment however she pleases. She can register it in South Carolina or wherever my client may live.
Repeated failures to pay show a pattern that could push the case toward jail time.
Or work or whatever. She's got all the information, but she can do that. It's not appropriate for the court to find somebody in contempt to enforce a money judgment. That just is not proper under the rules of civil procedure. So, given that he's and the payment of $4,000 that he made this week brings the payments current through August, that should be the end of this, and these proceedings should now be dismissed, and she can collect. Kurt's been in compliance with your order of $1,000 a month since October 2022. With regard to the arrearage calculation, we believe the arrearage calculation is an error. And if you look at Exhibit 2, that's the arrearage calculation.
Arrears or interest?
The judgment arrearage calculation, that's on the exhibit to the motion, I guess is what it is. No, Exhibit 2, that's the exhibit to their motion. That's the arrearage calculation on the judgments.
Well, it shows interest judgment on what I'm looking at.
Well, what I have for his Exhibit 2 is it says it's his Exhibit A to the motion to impose jail sentence.
Okay, I think we're looking at the same document.
Okay, that has those old judgments that were entered going back from day one in 2018. Then it has a list of payments that were made. And if you'll go down to about on page 6 of Exhibit 2, about midway through there, you can see there's a rate change, an interest rate change there. And then right above that, there's a payment of on June 13th of 2023 of $1,500. Well, what's happened is that Ms. Stevenson's not giving him credit for a payment that he made on June 20th. And I will then move the court to Petitioner's Exhibit 4, page 14, and it's just a little bit past halfway down the page there. You can see there was a payment that was made on June 20th. I don't know why the KPC broke it up, but you'll see a figure of $550.39 and a figure of $449.61. Those payments total $1,000, which is what I believe was really sent. And both those noted as being received or processed, on June 20th. So if you go back to now Exhibit 2, on page 6 there is no payment reflected, no credit given for that $1,000 payment that was made on June 20th of 2023. So that's going to render the entire computation set forth here, interest and principal, both incorrect. So I'm asking the court to note that Petitioner's Exhibit 2, while it is entered into evidence, is improper, is not an appropriate calculation, and must be disregarded until that payment's given its full credit. So we can't rely on that arrears cap in its present form, is what the point being there is. With regard to the request for a judgment for accrued interest, Judge, we don't contest. We acknowledge the fact that pursuant to KSA 16204, all judgments earn interest in the state of Kansas. However, to grant a judgment on accrued interest is contrary to what Kansas law says. Under Kansas law, it is inappropriate and improper to use compound interest on judgments. It must be simple interest. KSA 16204, as I said, the statute does not contain a provision or permission to use compound interest. And frankly, when you look at his Exhibit 2, Petitioner's Exhibit 2, I'm a little unclear as whether they're computing interest based on the entire balance due in the total column or just in the principal column. Because under Kansas law, you can only compute interest, simple interest on the principal, not the accrued interest. So the request to reduce accrued interest to a judgment is contrary to Kansas law, because then that judgment of accrued interest begins earning interest itself as interest on interest. That's compound interest, not permissible under Kansas law. In support of that, I would cite the case of Warnke versus Warnke, 12 Canap 2nd 506. It is a 1988 opinion. At page 514 of that opinion, the Court of Appeals says, first, regarding the computation of interest, it is settled that interest on judgments may not be compounded. A judgment creditor may only receive simple interest on an award. And they cite to and rely on the case of Hamilton versus Netherton, which is 194 Kansas 683, and that's a 1965 case. So it's clear under Kansas law that you can only have simple interest on judgments, and to reduce accrued interest to a judgment, which then earns judgment, runs afoul of Kansas law because you're trying to accrue interest on interest, which is not permissible under the law. So that is an improper request under Kansas law, and I would ask the court to very clearly overrule that. With regard to Exhibit 9, and you'll note that the last payment that was made until earlier this week was in April of this year. You'll note in Exhibit 9, there's no pictures, there's no social media, there's no nothing after April of this year as well. What does that mean? It means that there has been no money to do anything with. He hasn't been doing anything. He's entitled to court a wife. He's entitled to go out and do things. And during that period of time, for the most part, his payments were being made. Is it a perfect record? No. But we've had 35 months since the order for $1,000 a month, and that $35,000 have been paid. So he's paid what he's been required to pay. But know that there's been no, and obviously Ms. Stevenson has nothing better to do with her time apparently than to stalk and search and see what, Kurt and his fiance, now wife, have been doing. Well, that's her prerogative, but you can see there's been nothing since April, which would clearly support the fact that since April, he hadn't had any funds to do anything with. So the court should take that into consideration if the court's going to give it any weight at all.
Doesn't have any funds because he spent it all in April?
We don't even know. There's no evidence of who paid for the wedding. My client would probably testify that his wife paid for that wedding. Brides typically pay for the weddings. It doesn't look like an overly extravagant wedding. In that part of the country, weddings happen on the beach quite often, I believe. But I don't believe there's been no showing of that it was Kurt's money that's done any of this. None. No discovery was done. They haven't asked for anything. They just want to put social media pictures on the court. And they want to put LinkedIn things on to inflame the court. The bottom line here, Judge, is that he's complied with the court order. Has it been perfect? No, it has not been perfect. Has it been stellar and clean? No, it hasn't. But one thing's for sure, Kurt's always been able to catch up his payments. He's been struggling, obviously. You heard Mr. Venduska refer to his prior bout with cancer. Yes, he did have that. His business has been not doing well. Of course, you're not going to put on LinkedIn. You're not going to put on your corporation
Photos and social media are used to question whether the defendant could afford to pay.
website. Hey, our customers aren't paying us. We're having trouble getting funds to move forward with our business. You're not going to put that on social media. You're not going to put that on LinkedIn. You're going to puff up. I can't tell you how many resumes of people that come in here interviewing for a job that, say that this is the best employee I would ever be able to hire. That's normal. That doesn't mean that it's true necessarily. Of course, you're not going to put out there that you're not doing well. So I think, again, the court can take that into consideration and how much weight the court's going to give that. The bottom line is, and Kurt would testify, he's told me he had to sell a car here in the last month or two. He's been seeking odd jobs. Last I heard, he was working on a farm to try to make some extra money to get some funds in. And what's happened now is a customer paid a bill that was due, I think he told me in January of this year, just now got to pay, which enabled him to make this $4,000 payment. Otherwise, we wouldn't have that. But he's always been able to get the funds paid. But I would tell you that from my point of view, Kurt's not refusing to pay. He just simply can't. He's demonstrated, in my opinion, good faith for nearly 3 years now by complying with your order to pay $1,000 a month. That, frankly, should take care of any supportive urge that there would be. So with that, we're left with money judgments. And the court should not be involved in money judgments. I think it's improper for the court to be involved with money judgments. She's got her money judgment in a divorce. She can go collect it like any other judgment creditor. That doesn't warrant an award of attorney's fees. We don't assess fees against judgment debtors because they can't pay, or they don't pay, or they won't pay, or whatever the situation is. There's plenty of cases out there where there's professional judgment debtors out there. They don't pay. We don't assess fees against them for not paying. That's not appropriate. The purpose of a contempt and where it comes again on support is to encourage payment. And that's what we've got. Has it been, again, a perfect record? No, but he's paid everything that he should have paid under your order from 35 months ago. So it's our position that this should be dismissed, no more review dates, because the support position has been paid. It's just a money judgment now. She can go collect it however she wants. There is no reason for any attorney's fees. Attorney's fees is not going to encourage compliance. It's going to basically increase a nearly unpayable debt that my client's facing right now. It's going to add to that. It's not going to encourage payment. It's going to almost have a look at converting this to a matter of punishment, not coercion, or not encouragement to pay, which is what a contempt's supposed to do initially. And it's what's happened. He's paid what the court ordered him to pay. Again, but since the support's paid, that should be done. And this matter should be dismissed. No attorney's fee should be awarded. And no sanctions of any type should be imposed.
All right, thank you, Mr. Cranmer. Mr. Vendeska, I'll give you a chance to respond, but I want to take a short recess. I want to go back and review a few of the documents first before I allow you brief rebuttal. You're muted.
Thank you, Judge. So it just wasn't clear. Should I go ahead and then you're going to take a break, or?
I just need a couple minutes. I want to review the prior court order, and I want to review a couple aspects of your motion real quick before I allow you to give rebuttal. So I'm just going to take a very short break.
Yes, sir.
I'll call this a short recess. All right, we'll go back on the record. Same appearances as before. Mr. Vendeska, I'll allow you to make some rebuttal at this time.
Thank you, Your Honor. Judge, I'm going back to these that we're talking about. These are amounts due 6 and 7 years ago. But to speak to Mr. Cranmer's points, Judge, these are divorce judgments, and there's specific language in the divorce journal entry of a time frame for them to be due. This was a hearing with Judge Ward back in October of 2018. The journal entry of judgment regarding final division of assets and debts filed in the case on November 8th of 2018 awards my client a judgment of $55,327.89 for her portion of the equity in a Florida house in Boca Raton. That was to be paid by Mr. Ziemer in 90 days. So there was a date certain. It also awarded her, on top of that, an overall asset and debt equalization payment. So the first thing I mentioned is on page 4 of the journal entry. On page 5.
The original journal entry?
Well, there was one, I believe there may have been a bifurcation, but this is the journal entry of judgment regarding final division of assets and debts and spousal support filed in the case on November 8th of 2018.
All right, go ahead.
Okay, so page 4 of that document, and that's the numbered page because there's a judge signature page on top of it, but the page that's numbered 4 basically awards her the equity judgment of $55,327.89 to be paid within 90 days. In addition to that, on page 5, there is a reference to a equalization payment owed to her by Mr. Ziemer, which is based upon the overall asset and debt division of $32,016.45. Again, page 5. Also to be paid within 90 days of the date the journal entry is filed, the same time frame as the other amount. There was also memorialized on page 6, going over to page 7, temporary order spousal support arrears of $10,097.27 that hadn't been paid, but that were due on a monthly basis prior to that point. In addition, there were ongoing an additional 18 months of spousal support due November 1st, 2018, and by the first day of each month thereafter for 18 months in the monthly amount of $1,949.61. So, my response to Mr. Kramer's argument is these are all time-driven judgments. They're not traditional civil action creditor judgments. There is a time frame. The time frame is long past, and Mr. Ziemer failed to pay it. The court has the authority to compel his payment through a contempt action because he didn't follow the original terms, the time-sensitive terms of the original award. Beyond that, Your Honor, I would also argue that these objections weren't made when you originally found him to be in contempt and entered payment or repayment terms. So I would think that they're waived at this point in time. It's immaterial because there is a time frame for these payments. And again, they're not just vanilla creditor judgments on a balance that was unpaid that did not have a time frame for repayment. These absolutely had a time frame for repayment. Judge, speaking to page 6 of my packet, which is Exhibit 2, which is it is an amortization schedule, which is the interest calculation. It's not an arrearage calculation, but it does track all the payments. And what's reflected on this printout is not all of the Kansas Payment Center payments. Those are not tracked on this. What's reflected on this document is all of the court-ordered judgments, and those are noted in the memo section on the far right-hand column. So the first thing listed is the judgment from the journal entry, and the $97,941 is the combination of the $55,327.89 and the $32,016.45 that I just mentioned previously. Then basically, and I'm not going to go through, but each document, but you can see the order on the right-hand column, and there was then, Your Honor, frankly, we've had ongoing problems. There was a motion to enforce that we filed in 2019. And at that point in time, the court
Requests for jail time, attorney's fees, and interest keep the courtroom on edge.
awarded a judgment for the spousal support that was outstanding at that point in time as an additional judgment, and then also awarded attorney's fees. The other thing that's tracked here, Your Honor, this is a simple interest calculation. This is not compounded interest, but based upon 16204, the interest rate is set by statute. And so what that means is basically it has to be, it's based upon an amount. I'm reading from 16204 E1. The amount, sorry, let me put this in front of me. Except as provided in the subsection, on or after July 1st of 1996, the rate of interest on judgments rendered by the courts of this state pursuant to the Code of Civil Procedure shall be at a rate per annum of A, which shall change effective July 1st of each year for both judgments rendered prior to July 1st and judgments rendered during the 12-month period beginning July 1st, which is equal to an amount that is 4 percentage points above the discount rate. In parentheses, it says the charge on loans to depository institutions by the New York Federal Reserve Bank as reported in the money rates column of the Wall Street Journal as of end of parentheses as of July 1st, preceding the date of the judgment was entered. The Secretary of State shall publish notice of the interest rates provided by this subsection E1 not later than the second issue of the Kansas Register published in July of each year. So that's where the interest rates have come from. There is a notation in the center column. Basically, I believe there are three or four different changes of the interest rate based upon the statute. So in the memo column, and again, This does not track the KPC. This tracks the court judgments because we've had to memorialize the outstanding balance of spousal support for Mr. Zemer because he refused to make payments. That was last memorialized in the court's contempt order for October 11th of 2022, which you can see that about the first third down the page in the far right memo column. What's also reflected in the payment column, which is the second column from the left, are the payments. So after the original judgment in October of 2018, the journal entry was filed in November of 2018, Mr. Zemer made no payments. The Boca Raton house was ordered sold. The proceeds from that sale were $60,770.05. That got applied towards the overall judgment and reduced the judgment. That's the first listed payment in the payment column, $60,770. Thereafter, the Kansas Payment Center, Your Honor, after the court entered its judgment confirming the amounts due that were still due and owing after the contempt hearing or at the contempt hearing in September of 2022, we have those amounts listed that the court memorialized, and thereafter, then it does begin to track the Kansas Payment Center payments. And I believe it's accurate if Mr. Cranmer believes that there's a payment that was made but not recorded through June of 2025, from October of 2022 through June of 2025, I would encourage him to point that out. I believe that, but I believe they're all listed. So it's my intent and purpose and representation that this interest calculation was prepared based upon the normal practice using statutory interest and changes of interest, recording the judgment amounts awarded, recording the dates and amounts of any payments made, reducing the principal amount. The interest is accruing per statute on each amount from the date that that judgment was originally entered. Judge, as far as the remark about awarding a judgment for interest that then would earn additional interest, what we're seeking here is for the main purpose is for the court to make a determination that this is the outstanding interest owed as of this specific date and memorialize that amount. That is an amount we're entitled to collect. The underlying remaining outstanding principal balance is what will continue to accrue interest from this point in time. We're not seeking interest on interest. I appreciate Mr. Cranmer making that point. Your Honor, as far as Exhibit 9, that is a printout that my client got to me in June. I don't know why. I haven't asked her why there's no postings from after that date. The purpose of that, Your Honor, we're only asking that the court review those and draw the conclusions that a normal, reasonable person would draw from what's shown in those pictures. And again, I used this somewhat preemptively because there was kind of a dog and pony show last time about all of the justifications of why Mr. Zemer hadn't paid. And as far as his current financial position, there haven't been any affidavits submitted, not even a domestic relations affidavit. Your Honor, we haven't asked for discovery because frankly, my client doesn't have, she'd like to be able to use the $1,000 when she receives or any of those amounts for her living expenses, which they originally intended for. Engaging in discovery would be expensive. In my past experience, while the divorce was pending, we were underwhelmed by the responses because they were incomplete, leading us to have to then file motions to compel. So our design, we don't have our sights set on entering discovery here because I think we will not be dispositive of these issues. And again, the court has no evidence other than counsel statements that there's any issue with Mr. Zemer's ability to pay. But again, weigh that on what he's putting out there publicly regarding his current finances. Your Honor, I just renew our original request. If there's any other points raised by Mr. Cranmer or relating back to my original arguments that the court needs clarification on, I'd be more than happy to provide that.
All right, thank you, Mr. Vendeska. Mr. Cranmer, was there anything else you wish to add?
Yes, Your Honor, I was certainly, I don't think I ever contested the interest rates that was on Mr. Vendeska's Exhibit 2. The only thing I really contested was he didn't give us credit for the June 2023 payments, which again throws this whole thing off. I also, if I said this, I didn't mean to say it. I didn't say or mean to say that Ms. Stevenson isn't entitled to collect, interest on her judgments. That's not what I was trying to say. I don't think I said that. If I did, I misspoke, and I apologize to the court and counsel both. But what I'm saying is you can't reduce that amount to a judgment. And the court could make a finding that the arrears is principal amount plus accrued interest. But the accrued interest cannot be a judgment because it cannot earn interest. That would be an improper compounding of interest, which is not allowed under the warranty cases I've cited in the court. And again, with regard to, I think the court should give weight to these exhibits. Whoever wants to enforce a contempt has a burden of proof. I don't have the burden of proof. They have the burden of proof to show that he's willfully disobeying the order of the court. Well, I think we've shown he's complied with what's to be complied with.
Defense argues hardship and partial compliance, illness, business struggles, and past payments are highlighted to avoid contempt.
I would also note that,
Well, the court's already made the finding of contempt.
but he's wanting to impose a sentence based upon somehow we failed to follow the court order. And I'm saying we have followed the court order. It's not been perfect. But he's under your order. He should have paid $35,000 as of August, and he has. So I don't see any reason at all for an imposition of any sanction at all.
Well, Mr. Cranmer, as I read the contempt order was not only for let me find the language. The order from the original contempt hearing filed October 11th, 2022. As the court enters judgment against the respondent in favor of the petitioner in the amount of $27,294.54 for the unpaid spousal support owed for the months of March 2019 to April 2020. Paragraph 3, the court finds the respondent in contempt of court for his failure to make the monthly spousal support payments owed to petitioner and payments toward the judgments contained in the journal entry of judgment regarding final division of assets and debts. The court will allow the respondent to purge the contempt by paying $1,000 a month commencing October 15th and the 15th day thereafter. So the contempt finding was for not only the failure to pay the spousal support, but also for the other judgments that Mr. Vendeska referenced earlier that had a date certain for payment under the original order.
And I would submit that any judgment that has a date certain for payment becomes a money judgment if he doesn't pay it, and that date's passed, and to impose certain sanctions on or conditions on that after the fact is an improper modification of the judgment.
Do those cases that you cited support that position? Or were those regarding the compound judgment interest?
The cases I cited today were on the compound interest on judgments.
So it's your position, Mr. Cranmer, that the original payments that had a date certain for payment in the original court order aren't contemptible? If he fails to pay, the court can't find him in contempt for that?
That would be my position, because it's just similar to a money judgment. I mean, the money judgment, somebody didn't pay on time, so they get sued and have a judgment entered against them. That's what happened here.
Do you have any legal authority that supports that position?
I don't have it today. I would also submit that everything's been reduced to judgment now, so they're all money judgments. Ms. Stevenson has had the council come in and they've reduced all these different money judgments, and that's, they're all kind of set forth on their exhibit 2 in the I guess the third column under loan. All those are the money judgments that have been entered. And so I'm submitting to the court just even by their own exhibit. These are money judgments they're trying to enforce now.
Well, looking at the original contempt order, basically the order was that he pay $1,000 a month to purge himself of the contempt, which he's missed some payments and been late on payments, but apparently is caught up at this point. Would you agree, Mr. Vendeska, that he is caught up now after making that $4,000 payment?
Mr. Kramer sent me, I think, a screenshot of that. I don't know that it's been processed through. I guess I'd have to ask my client about that. But our position, well, the 4,000 was the amount that was owed and outstanding as of per the calculation. So I don't know if Ms. Stevenson has received that amount. It wasn't reflected in the Kansas Payment Center because the timing was yesterday or the day before, I guess. And Your Honor, I would renew just very, very briefly. I mean, if Mr. Kramer's position is that there can't be contempt due to failure to make timely payments on certain judgments, well, that was memorialized. That was exactly what the court entered in its order, a contempt for these failure to pay these amounts and the purge amount based upon payments going forward. Mr. Kramer didn't file a motion to reconsider. He didn't appeal that order. That basically, he's waived the opportunity to make that argument. I don't agree it's a valid argument in the first place, but that's my perspective. I don't think he can raise that now because this is something that relates back to the court's order from September of 2022, where those were treated as judgments that he was deficient on, not only the amount and the timing, and therefore was found to be in contempt.
Well, my client didn't have any money to appeal it or file motions to alter or amend or do anything like that. I mean, people just don't have that money.
Counsel, I understand the arguments. That have been made here. I hate to do this, but I need some time to go back and look at all of this and look some things up before making a ruling. So I'm going to take this matter under advisement. I don't want to take it under advisement for a long period of time. Angela, do we have a 30-minute window? About 30 days out, we can squeeze this where I can give an opinion ruling.
Judge, I have September 24th at 3 o'clock.
September 24th at 3 o'clock.
Your Honor, unfortunately, I'm in an all-day mediation on that day.
I have September 26th at 9 o'clock.
Judge, can I have 1 minute to go get either my phone or my calendar? I didn't bring either one.
Yes.
1 second. Thank you.
I know Mr. Kramer will speak to his availability, but I could do 9 o'clock on the 26th.
Okay.
Okay, what date are we looking at now?
September 26th at 9 o'clock.
That will work with me.
All right, and we'll do that by Zoom again. And I'll either issue an opinion ruling on that Zoom call, or sometimes if I find it more appropriate to put something in writing, I'll prepare that and file it ahead of that date.
Okay.
Mr. Vandeska, anything else you feel needs to be addressed today?
I don't believe so, Your Honor. I appreciate our opportunity to appear today.
All right, Mr. Cranmer, anything additional today?
Is this a 9 o'clock hearing on the September 26th? Is that like an hour time slot, probably, something like that?
I'm just going to be issuing a ruling, which I usually just set aside 30 minutes to do so. I don't anticipate I'll need longer than that.
All right, thank you.
So, all right, well, thank you, everyone, and we'll see you back on September 26th.
And it will be the same Zoom link.
Okay. Thank you, Your Honor. Thank you, Ms. Cool.
All right.
Judge takes matter under advisement. Suspense peaks. Lawyers debate legal authority, and the court sets the next hearing, leaving viewers waiting.